what are the essentials of a contract of sale? When we can say that, when we can say that this is a valid contract of sale? The first essential is a valid contract. As we know, there are a few provisions under Section 10 of Indian Contract Act 1872 regarding the validity of a contract. All those valid point, all those valid essentials must be present even in a contract of sale. If any of them is absent, it would lead the contract to void or voidable. That means if any contract includes all the essentials of a valid contract under section 10, so that would even be called as a valid contract under the contract of sale too. Next is two parties. There must be two parties in the contract of sale. One must be the seller, another one is the buyer. So see the example. A club supplies food and drinks to its members at the fixed price. This was not to be this was held to be not a sale, as a member of club pays to the members jointly, that is to the club. The members of club are undivided joint owners and not part owners. That means for a valid sale there must be at least two parties into a contract. There are certain exceptions to the rule of the two parties. One, where a person's goods are sold in execution of a decree, he may himself buy them. Means if any kind of decree, execution of decree is there, the person can buy his or her goods himself or herself. A part owner can sell his share to the other part owner. Means if there are more than one owner of the goods, that means a part owner means Mr. A, if has Mr. A and B jointly hold a particular article, Mr. A can sell his share to Mr. B, the other part owner. In that case, the seller can sell the goods to the seller only. Next, where a pawnee sells the goods pledged with him on non-payment of bill money, the pawner may himself buy such goods. That means when the pawnee, in case of default made by the pawner, sell the goods pledged with him for recovery of the money for non-payment of the bill money, in that case pawner himself can buy his own goods. A partner may also buy the goods from the firm in which he is a partner. Means if any partnership firm is selling the goods and the partner from even that firm can purchase the goods. In case there is a sale by auction, the seller may reserve right for making a bid. Even the sale, even the seller in an auction can give bid for the goods to be sold in the auction. Means these are the exceptions to the essential of two parties for a contract of sale. Third essential is agreement for the transfer of ownership. There must be immediate transfer of an agreement to transfer the general property in goods sold or agreed to be sold. Means if only the physical possession is being given, this cannot be held as a valid sale. Means physical possession may or may not be given, but the ownership of the goods, the immediate transfer of ownership must be transferred immediately for making a contract as a valid sale. Next is the goods. Goods are the basic subject matter of a contract of sale, and goods means every kind of immovable property other than actionable claims, money, and also includes stock, shares, growing crops, grass, trees, and things attached to it or forming part of the land. Let's see the example. Where the trees were sold so that they were to be cut out and separated from land and taken away by the buyer. The contract was the sale of trees as movable goods. That means when the trees are being sold before the cutting for the purpose to be cut out in future and to be taken away by the buyer, so this contract is a valid contract of sale. Here money, actionable claims and immovable property are excluded from the definition of the goods. So what we mean by all this? First is the money. Money is a legal tender, and for every sale there must be a money present in that money, or something in the form of money. That means the money cannot itself be the subject of the sale in the contract of sale. So that is why the money is being excluded from the definition of the goods. Next is actionable claims. Actionable claims means claims which can be enforced by a legal action or a suit. These can be transferred only under the Negotiable Instrument Act 1881, so cannot be treated as goods for a contract of sale. Next essential is the price. Price is the consideration for transfer, that may be money or that may be promise. Means something in consideration for the purchase of goods, for the selling of goods is called as a price. Normally consideration the transaction is not a contract of sale. Without consideration there is no contract of sale. Consideration, yes, it is possible, maybe partly in the form of money or partly maybe in some other articles of the value. Let's see the example. A refrigerator company supplies a new refrigerator of rupees 9,000 in exchange of old refrigerator and rupees 6,000 in cash. That means total cost includes two parts of the components, two parts of the consideration. One, the old refrigerator, and second, the rupees 6,000 in form of cash. So it's a sale under the Sales of Goods Act.